particular purpose. And the bench is just a mere conveyor belt, and that the parties herein will not have the chances to have justice of their case being dispensed. Your Lordship, I have annexed a tweet by senior counsel Ahmed Nasir, annexed in our affidavit at paragraph 12, and I wish to read that tweet, Your Lordship. Ahmed Nasir, Your Lordship, is a senior member of this bar, a senior counsel, and Your Lordship, here it goes. The conservatory orders will be discharged by the 3-judge bench, latest by next week, if not by Friday. Even as we approach you, Your Lordship, the perception out there is that this bench is part of the conspiracy.
Ahmed Nasir is not the law.
Your Lordship,
He speaks not to the law. Ahmed Nasir has also an affidavit. He's not a witness, my lord. How does Ahmed Nasir, and we have 64 senior counsel, how does Ahmed Nasir, how can his tweet inform submission before this court?
may I answer that, Your Lordship, to the good professor, that we are speaking about perception. The standard of a bystander, the reasonable man, a fair-minded man in the status and the character of a senior counsel, Ahmed Nasir says, and the president's lawyer says, we cannot receive justice. That is the standard.
Ahmed Nasir says that this court will quash.
Mr. Ojienda, you have your time to respond.
No, but the point is, he then speaks in your favor. Pick that line.
You will not teach me how to submit. You will pick the line that you so wish. For me, I am saying, Your Lordship, that the perception out there is that this bench has been constituted as a conveyor belt. Finally, Your Lordship, this court will remember that on the 16th of October, we moved the court for a mention on the 18th. The court declined to grant that mention and slated our file to be mentioned on the 29th of October. But when they were moved by parties in these proceedings, the court was generous and gracious enough even to sit on a weekend, to sit on a Saturday. Noting that we were before you, you slated our matter for the 29th, and never saw the urgency. Your Lordship, how can a fair bystander be convinced that this court will dispense with substantive justice? How can it be said that this court is impartial? Your Lordship, the question of a spouse being linked to a judge, as indicated by Rules 47, is of paramount importance and something that cannot be ignored. Why did the court disclose to us? Why did the court conceal? If the court can conceal such kind of apparent evidence, what else is it capable of concealing? Your Lordship, permit me to indicate that in our affidavit that would wish to expunge paragraph 16 of our affidavit, supporting affidavit, will not rely on it, and paragraph 10 of the same affidavit will not rely on the same. But the standard, Your Lordship, is that of a bystander. Ahmed Nasir spoke, and he has a following of over 1 million on his Twitter handle. That is, the perception has been created to the Kenyans that this bench, 1, is a conveyor belt, 2, it is considered for a particular mission, 3, it's part of the conspiracy. Your Lordship, we urge you to uphold our application and grant the prayers sought. Your Lordship, my learned friend Mr. Masharia will highlight on the authority, with the authority in support of my submissions and those of Kide.
A slight clarification on the expansion. Paragraphs 10 and 16, if I had properly,
Yes, that's correct.
of people supporting affidavit.
That's correct.
I don't know whether we can do that. To oral submission, you cannot expunged a paragraph from an affidavit as it is evidence before the court, and it has to be considered, it has to be challenged in all ways. Number two, if you expunge paragraph 16,
Can you cover it in the response, please?
I may,
Yes,
but
it's just correct.
if you expunge 16, I have a problem with that. There is no application before you. If you expunge paragraph 16 from the affidavit, there is no application has been added for you. So we need all this clarification. Let's not take things lightly.
Yes, Your Lordship, yes, it is true that the paragraph that I seek to expunge is paragraph 16.
Paragraph 16 of this affidavit, my view.
Who's affidavit?
The way the applicant's affidavit. That is Obuli Namenya.
My Lord, permit me my Lord, again, because we have to be fair to the court, my colleague has to be candid and confirm to the court. The reason he is withdrawing that paragraph 16 is because the claim there is factually false. Because he can't just withdraw and leave the world thinking
I
it.
haven't seen that paragraph 16. Can you read it? The paragraph 1.
Your Lordship, are you having the same application?
Read as paragraph 10, which you want to withdraw, and paragraph 16, so that we can consider if it can withdraw.
Yes.
And confess it's a lie.
We give Mr. Ndegwa, my Lord, your leadership the opportunity to finish.
Yes. Let me read those paragraphs
Yes,
so that we can sit down.
no, I agree. I'm just saying, protect him from these tutorials that he's getting from this.
Please read as paragraph 10.
Your Lordship, I wish to say that most respectively, I wish to say no more with respect to the paragraph.
This direction to court, read paragraph 10.
16, oh, paragraph 16,
Paragraph 10.
May I have some peace, Your Lordship? How many people are in conduct of these trials, Your Lordship?
Listen.
Who is in conduct?
Listen. Njiru,
Yes, Your Lordship, I agree.
you have applied to expand
Yes, Your
paragraph 10 and paragraph 16.
Yes, Your Lordship.
Can you read those paragraphs which you intend to expand?
Your Lordship, paragraph 16 says that.
Paragraph 10.
And Your Lordship, may I take note that these paragraphs have been expunged? One,
You have to expand those paragraphs.
that there has been an application to expand them. The petitioners have credible information that Honorable Mrima is a close associate to the proposed deputy president, one Mr. Kidore Kindiki, and that the said judge failed, refused, or neglected to disclose those facts to the parties at the inception. The basis of the application to expurge that particular paragraph is on the basis that the same has been linked to the affidavit sworn in petition 015. Paragraph 16, that Lady Justice Mugambi is convicted as she should excuse herself, as she was Mr. Kidore Kindiki's LLM student at Moi University.
You have no LLM program at Moi University.
You will have your time to submit, sir. And that's why I'm expanding. That's why I'm expanding this paragraph. That is what my client said. A crucial issue that she failed and or refused to disclose to the parties. My client has learned that she was not an LLM there and that she only took her degree in that university.
We have no objection to anything being expunged, subject to the court observing that if this witness has lied about these two issues, what else has he lied about?
Isn't some issues to be made?
In a ruling, because application has been made and the response is there, but we decline the invitation to expand, they will remain as part of the record.
We are most obliged.
Dr. Kamala, we would appreciate if you want to address us in the course of the as in your submitting. Is that the position?
Yes.
Okay, proceed.
Position is that if there is a party,
are you supporting the motion?
I'm supporting my running friends complaint to be able to do as my friend.
You need to go.
Let's go for that.
Oh,
Yes.
yes.
Yes. Yes.
You can operate it myself.
Yes.
Thank you very much, to my senior. My lords, I'll take about 15 minutes. Mercifully, my issues are issues of law. They will not incite any shooting up from a opponent. We should not. My lords, I have my lords in the leadership. I have submitted some two cases. The first case is the case of Standard Chartered Financial Services and another versus Manchester Outfitters. I don't know that you have that with you. And the second is a case called Naveen Premjikerai versus Bureau Limited and others. In the case of Standard Chartered Financial Services Limited versus Manchester Outfitters, and this remains, as far as I'm aware, the first case where the Court of Appeal reviewed a judgment, a concluded judgment, set it aside and varied. And the only question before that court that led to this decision was the question of bias. I invite my lords and your lordship to paragraph 1 of the decision, where the court says as follows in trying to frame the seriousness of the issue. And I'm reading from the second line. It is a rare application in which the applicants seek to have the judgment of this court reopened, re-examined, declared nullity, set aside, and the appeal had fresh. I invite you now to go to paragraph 9. We've done back-to-back a photocopy, but if you look at paragraph 9, in the middle is in bold the words Jasbir Singh Rai and two others versus Talukan Singh Rai. And the court is saying what it held, and it says this. During the pendency, my lords and your lordship, are you there? In the middle of paragraph 9, during the pendency of the applicant's motion and the respondent's preliminary objection, this court, in a 5-judge bench decision in Jasbir, and they give the whole case they held inter alia, that it was only mandated to hear and determine appeals from the High Court and could not revisit its own previously concluded decision, nor did it have powers to reopen and rehear and finally conclude the matter. In light of the decision in the right case, it was deemed appropriate that since this matter raises similar issues, it be similarly heard by a 5-judge bench, hence the unusual composition of this bench. They are merely underlining the importance of the matter the court is dealing with. Permit me now, your lordship and my lords, to invite you to paragraph 63, where the question that vexes you this afternoon is dealt with. At paragraph 63, they deal with a case which we've also supplied the court and my friends with. This is a well-known case of Senator Agostino Pinochet. But at paragraph 63, this is what they say. Bias, whether it is perceived or actual, undermines the public confidence in a judicial officer's ability to dispense justice. They then cite a caption by Lord Jock in R versus Gao. Justice must be rooted in confidence, and confidence is destroyed when the right-minded people that Mr. Ndegwa was talking about go away thinking the judge was biased. At paragraph 65, the case of Webb versus Queen, in considering the merits of the test to be applied in a case where a juror is alleged to be biased, it is important to keep in mind that the appearance as well as the fact of impartiality has been done. And this is what they say at paragraph 6. And this, my lord and your ladyship, is what I would be beseeching this court to find favor with when you retire to the rule. The rule against bias is as important an element of the right to a fair trial. This rule, and now this is our own 5 judgments in this court of appeal, this rule is to be very strictly applied so that even the appearance of bias is done away with. The appearance of it. This is because it aids in public confidence in the fairness and impartiality of the judicial system. In view of the jurisprudential importance and uniqueness of this application, they then cite a case called R versus Sussex. Justice should not only be done, but should manifestly and undoubtedly be seen to be done. I will leave for you to read paragraph 67, which I also recommend to you. And then paragraph 71, another English case cited. First, actual bias will of course always disqualify a person from sitting in judgment. Even in the absence of actual bias, however, the importance of public confidence in the administration of justice is such that even the appearance of bias will disqualify. And we say emphasis added. And I would also invite you to look in the fullness of time to paragraph 73 and 74. Paragraph 81, they cite the case, cited earlier, I think I mentioned it. This is the case of Agostino Pinochet. It actually begins at paragraph 80. There's a long passage, I'll not read it on account of time. But at paragraph 81, they cite the basis for the reason the 2 applicants before you have moved.